Good morning, Your Honors. The matter before the court this morning is the case entitled In Re DP, case number 24AP205. Representing the appellant, DP, is Addison Kalupa, and representing the appellee, the state of Vermont, is Robert Sedek.
Thanks very much, and good morning again, everyone. We'll hear from counsel for the appellant. Please introduce yourself, identify your client, and then proceed.
Good morning, Your Honors, and may it please the court. My name is Addison Kalupa, and I represent the appellant, DP. I'd like to reserve 1 minute for my response. This case comes on appeal to review a judgment of the Orleans County Superior Family Division and involves a question of whether the evidence is sufficient that DP met the criteria for further treatment under 18 VSA subsection 7620. It also involves the issue of whether the trial court can order involuntary medication absent a finding of no less objectionable available treatment. Of central importance to this matter.
This is for an order of non-hospitalization, correct?
Yes, that is correct.
So he's got an order of non-hospitalization with a requirement that certain medications be taken.
Yes, Your Honor, that is correct. The court did find that DP was in need of medication, and that that would be a requirement that he does follow that medication. A repercussion for not voluntarily, coincidentally, not taking it would be that he would essentially face another court order. Essentially, they could either hold him at the mental hospital again, or they could move for, more likely, would move for the introduction of involuntary medication. Of central importance is Rusty, which is DP's dog. He had claimed that previously that this dog had gone missing and that he believed that this was due to malicious behavior. Trial court ultimately decided that that belief was delusion. The trial court, in doing so and making that finding, had relied upon the testimony of Mr. Aberdouin, who was one of the treatment providers for DP, and asserted that DP had met the diagnostic criteria for conditional delusional disorder. This is in contrast to the evidence, though, and it was not a substantial amount of evidence that was presented to certainly find that DP was delusional, because the court later stated the court does not disbelieve DP's claim that his dog went missing, but no evidence was presented to suggest that this was due to malicious behavior by another person or persons. So if DP is mistaken in his belief, it's not enough to meet the requirements for the delusion, because as DP further acknowledged during the hearing, he doesn't know with absolute certainty, but he reached that conclusion based upon the facts that he had before him in the context, meaning the past history with his neighbor, the phone message that was left by his presumed neighbor, somebody who he recognizes audibly as Mr. Haney, and then that message being, "Come get your dog." Further, the findings did not justify that DP was a patient in need of further treatment, because the treatment provider acknowledged that if the order was lifted, that he would not be sure if DP would continue to take his medication. And so under the statute, it needs to be sufficiently found by the court that he would not continue his medication. It needs to be something that's reasonable, and it's not reasonable because he's not sure. And the reason why we know this further outside of his testimony is because the application for continued treatment shows that this is referred to as a safety net for DP, and that it's not been enough time for them to adequately assess his long-term compliance. But yet the testimony differs from that. And so it's lacking the ability to say, okay, this is sufficient to meet the standard, and there's no evidence that providing a safety net is what's necessary, or that that's appropriate, because it's leaving Ms. DP essentially captive for an indeterminate length of time without the adequate findings that are necessary. Furthermore, the danger of stopping the medication was something that was found to be possible by this treatment provider. It's not concrete. In their own words, they said this is not something that's concrete, meaning that the standard of being substantial probability.
You have 1 minute, counsel. 1 minute.
I would like to reserve the remaining 1 minute. Thank you.
Okay, then we'll turn to counsel for the appellee. Please introduce yourself, identify your client, and then proceed.
Good morning. May it please the court, my name is Robert Sedek, and I represent the Department of Mental Health, the appellee in this matter. The appellant in this case contends that evidence at hearing was insufficient for the Superior Court to determine that Mr. Paulson was in fact a patient in need of further treatment, and that they erred in issuing an order of non-hospitalization. As the Superior Court's factual findings are being called into question, the court today should be applying the clearly erroneous standard of review. To reach their conclusion, the evidence before the Superior Court needed to show that Mr. Paulson was a patient who was receiving adequate treatment, and that if that treatment were discontinued, his condition would likely deteriorate and he would become a person in need of treatment. To be a person in need of treatment would mean that DP has a mental illness, and that because of that mental illness, he posed a danger of harm to self or others. And it's important for the court to keep in mind that this danger of harm can be shown by threats that place others in reasonable fear of danger.
So, Mr. Sedek, the fact that he has a delusional disorder, or he has a diagnosis of a delusional disorder, does that necessarily make him a danger to himself or others?
Not the mental illness on its own, but by being a danger because of that mental illness, which the testimony showed, that's what would make him a patient and a person in need of treatment.
So it was the behavior based on the diagnosis, not necessarily the diagnosis itself. It's a combination of the two.
That's correct. Many people have mental illnesses and can live normal lives, even people with delusional disorders and who don't need this sort of supervision or involuntary treatment, but in this case, DP does. So at hearing, DP's neighbor, Miss Catherine Rossi, testified that DP had approached her and threatened to kill her as she was hanging signs on her property, and this caused her to fear for her safety. As this was their first time meeting, DP did first explain that his neighbors were all out to kill him and that he would have to act first by killing them. And as she was his neighbor, that meant he would have to kill Miss Rossi as well. And this interaction was the result of his mental illness. Mental illness is a delusional disorder that was diagnosed by Mr. Abiadun, who is an expert in psychiatry, as well as Mr. Paulson's primary psychiatric care provider. Mr. Abiadun was able to testify for the court that DP has a delusional disorder, which caused him to think his neighbors were conspiring to kill him, as well as his dogs, and that he had immediately included Miss Rossi in this delusion when he met her. So this testimony from Miss Rossi and Mr. Abiadun showed the court that DP suffered from a mental illness, and as a result had caused reasonable fear in someone by threatening to kill them. After the incident with Miss Rossi, DP began receiving involuntary treatment. At hearing, the testimony was heard from Miss Cassidy Keith, who was a part of his ONH treatment team along with Mr. Abiadun, and her testimony showed the court that although DP seemed to be doing better with treatment, he continued to assert that he did not have a mental illness, and that if it were not for the court order, he would discontinue his treatment on his own. In an attempt at compromise, Mr. Abiadun agreed to reduce the medication being prescribed by 1/2, and this change saw DP decompensate to having emotional outbursts, becoming more agitated and more irritable. And these things were all diagnosed as symptoms of his delusional disorder. So for his own health and safety, Mr. Abiadun had to increase the medications for DP back to an effective dose. So based on that experience and Mr. Paulson's own words to him, Mr. Abiadun was able to tell the court that without a renewed ONH, Mr. Paulson would likely discontinue all treatment on his own and revert to a person in need of treatment in as little as 2 weeks when he was asked a timeline. And I'd also like to address the issue of the involuntary medications. Currently, DP is on a order of non-hospitalization, which is a form of involuntary treatment. To request involuntary medications is a specific application under Vermont law where a provider must follow the application process, present evidence at a special hearing for involuntary medications, and the court's order has to specify medications, dosages, and method of administration. In Mr. Paulson's case, no authority for involuntary medications was
You have
requested.
1 minute, counsel. One
Thank
minute.
No evidence was presented at a special hearing, and the court never issued an order that granted authority for providers to administer involuntary medications. The only order issued was that of the order of non-hospitalization, which is simply involuntary treatment. An order for involuntary medications would allow providers, if DP was not accepting oral medications, he could be physically or mechanically restrained according to the provider, and then receive an intramuscular injection of medications. So that is the involuntary part of involuntary medications, and that's just not an option with an order of non-hospitalization. As appellant said, it would trigger potentially a revocation hearing if he was not complying with the order of non-hospitalization, and then potentially he could be rehospitalized. But then again, that would trigger a whole new hearing, new evidence, and then involuntary medications could be sought. So in conclusion, the Superior Court's decision was based on substantial evidence presented at hearing, and we would respectfully ask this court to affirm their decision. Thank
All
you.
right. Thank you very much. How much time does the appellant have, please?
Appellant has 49 seconds remaining.
Counsel?
Thank you. In regards to the involuntary medication, DP was forced to essentially make a choice. He either agrees to the medication or he faces the order of hospitalization and further a potential hearing for the involuntary medication. The court had noted, the lower court had noted rather, that DP required antipsychotic medicine. Essentially, this makes it into not a voluntary choice. I mean, he's coerced into this position where it becomes a non-voluntary process and is absent void consent. There's just not enough there to legally force him to continue taking the objectionable medication.
So what's,
His-
Mr. Kalupa, what is the remedy for that? This isn't a situation, as your opposing counsel discussed, this isn't an involuntary medication as it's described in statute, which requires hearings and findings. What's the remedy you're asking for if you consider this in a different context as involuntary medication?
The remedy would be for that portion of the standing order to be struck and for the court to revisit this, because there needs to be findings there to put in this into place. There need to be findings that would support that, which specifically under the involuntary statute, Title 18, subsection 7624, under Part 8, they would need to consider what alternate treatments could have been proposed by the doctor, the patient, other reasons for ruling out those alternatives. And so simply because the court did not engage in that analysis, essentially bypassed DP's right to have that examined by the court. So we would ask that be reversed.
But Mr.
Okay.
Cooper, that is required only for involuntary medication, not for an order of non-hospitalization. That's where the court is requiring, going through all the things that Justice Carroll just said, to require medication be given involuntarily, correct? Am I right on that?
Correct, Your Honor. The point that we are making is that it became muddled in the lower court. It seems that the court overextended itself in DP's instance by going a step further by saying that he is required to take this antipsychotic medication, because by doing so, they essentially bypass the normal process, which would be if he doesn't want to take it or he's not taking it, that there should be a process through the courts to examine.
So if the court isn't allowed to do that in a non-hospitalization order, what's the purpose of a statute allowing for non-hospitalization if medication can't be part of that?
Medication potentially could be part of that, provided there is no objection. DP certainly does object. The appropriate use of the statute would be to examine an individual, do the psychiatric analysis, and engage in whether or not there's alternative processes or alternatives to medication that could potentially be used to essentially diagnose and then treat the patient.
Okay. All right. Your time has expired. Thank you very much. Please call a conclusion of the hearing.